Miss Fabian. Who's Earl Major? Oh, is it 11 o'clock?
Welcome to the docket where the legal clock is officially ticking. We're looking at a dual case call, but the real focus today is Eileen Fabian. She's not here for a trial, she's here for a plea. In the legal world, a plea hearing is like a high-stakes negotiation where you trade your right to a trial for a known outcome. But as you'll see, the known outcome for a third offense is anything but light.
Two, please. Okay. All right. I'm going to call Mr. Majors first. It's just an amendment. He's prepaid what he needed to pay. We will go on the record in the matter 24 CM 105, 24 TR 581 and 582, State of Wisconsin versus Earl Major. All right. We will go on the record in the matter 24 CT 39, 24 TR 280, State of Wisconsin versus Eileen Fabian. The state appears through Assistant District Attorney Kevin Schmidt in person. Ms. Fabian appears in person.
Notice how calm the defense attorney sounds. This is the start of a plea hearing, which means no trial, no jury, no dramatic objection scenes. Instead, Fabian is agreeing to plead guilty. But why would someone voluntarily plead guilty? Stick with me, because the answer is hidden in the judge's next questions.
With counsel, Joel Schlitz, we're set today for a plea and sentencing. I'm fully expecting that we are all good here today, Mr. Schlitz.
I believe we are, Your Honor.
Excellent. Plea, questionnaire, waiver of rights form, please.
May I approach?
You may. Thank you. Ms. Fabian, we have a plea questionnaire waiver of rights form here. Mr. Schlitz, she's pleading to the OWI third. And it's for IDIP recommendations, is that correct?
That's correct, Your Honor.
All right. All other matters would be dismissed and read in or merged and dismissed, correct?
Yes.
Ms. Fabian, I have the plea questionnaire waiver of rights form in front of me. Do you recognize the document?
Notice the judge's checklist here. This isn't just small talk, it's a constitutional safety net. The judge has to confirm Fabian is pleading knowingly, intelligently, and voluntarily. If the judge misses even one of these boxes, the entire conviction could be thrown out on appeal later. It's the ultimate procedural shield for the court.
You got to say yes or no, and yes. Please have the microphone to you. We have a visiting court reporter who needs to hear everything, okay?
Yes.
And is that your signature on the second page?
Yes.
It states that you are pleading guilty to one count of OWI third. Is that correct?
Yes.
Did your attorney go over this form with you thoroughly?
Yes.
That is word for word?
Yes.
Did you understand everything on this document?
Yes.
You're 60 years old. You have 14 years of schooling. You can read, write. You understand the English language. No drugs, alcohol, or other medications in the last 24 hours. No receiving treatment for mental illness or disorder. Is that all correct and true?
Yes.
You went over the charge with your attorney, what the state would have to prove. Is that correct?
Yes.
And your attorney went over with you the minimum and the maximum possible penalties you face. Is that correct?
Yes.
Because you're charged with crimes, you are entitled to constitutional rights, and each of these rights is listed on this document. Your attorney went over these rights with you thoroughly, correct?
Correct.
And you understand them completely?
Yes.
Do you need me to go over those rights with you in any more detail?
No.
Do you understand that by pleading guilty, you're waiving and giving up those rights?
Yes.
Do you understand that if you're not a citizen of the United States, your plea could result in your deportation?
Yes.
Do you understand that here, the state would have to prove on or around March 10th, 2024, in Burnett County, Wisconsin, you operated a motor vehicle while under the influence of an intoxicant, a misdemeanor. Upon conviction, this would be a third countable offense. If convicted, you face a fine of...
And here is the gut punch, strike 3. In Wisconsin, your third OWI moves you out of mistake territory and into mandatory jail territory. We're talking a minimum of 45 days behind bars and a multi-year license revocation. At this point, the system stops trying to give you a slap on the wrist and starts trying to take you off the road permanently.
less than $600, but no more than $2,000, and imprisonment of not less than 45 days, but no more than 1 year in the county jail. Do you understand that?
Yes.
Plus, the court shall order you to complete an OWI assessment and driver safety plan, as well as revoking your driver's license for not less than 2 years, but no more than 3 years. Do you understand that?
Yes.
Do you understand that the recommendation is for the court to follow the IDIP guidelines for sentencing? Do you understand that I don't necessarily have to do that?
Yes.
I could sentence you all the way up to the maximum possible penalties if I thought this case warranted it. Do you understand that?
Yes.
Do you still wish to proceed and enter a guilty plea?
Yes.
All right. Now, did you go over the criminal complaint with your attorney?
Yes.
In particular, that section that's called the probable cause section that basically says what happened that day and why you were charged with crimes?
Yes.
For the most part, are those facts accurate?
Yes.
Are you admitting here today that you, in fact, did operate a motor vehicle while under the influence of an intoxicant?
Yes.
And that would be your third countable offense.
Yes.
Mr. Schlitz, may the court use the probable cause section of the criminal complaint to find a factual basis?
Yes, Your Honor.
Has anyone made any threats or any promises to you for you to plead guilty to this charge?
No.
You're doing so freely and intelligently, telling the court you fully understand what you're doing here today
Yes.
and voluntarily.
Yes.
Has your attorney represented you competently?
Yes.
Has he answered all of your questions?
Yes.
Has he looked at this matter thoroughly?
Yes.
Are you satisfied with his services?
Yes, I am.
Any questions for the court or for your attorney before I proceed?
Nope.
As to count 1, OWA 3rd, in 24 CT 39, how do you wish to plead?
Guilty.
Court will find your plea of guilt is done knowingly, intelligently, and voluntarily. I'm going to find that you understand your constitutional rights and what it means to waive and give up those rights. I'm going to find a factual basis to accept your plea of guilt. Based on that, I will find you guilty of the count. The other count in that case will be dismissed and merged in with count 1. The TR matters will be dismissed and read in. A judgment of conviction will be entered today.
And just like that, Fabian is officially guilty. Notice how fast that was? No drawn-out trial, no endless objections. One guilty plea, a few confirmations, and boom, conviction on record. Ever wonder why so many cases end in plea deals? It's because they're quicker, cheaper, and almost guaranteed.
What was the BAC?
314.
All right. Argument and sentencing recommendation, Mr. Schmidt.
I think the IDIP program benefits both the rehabilitation of offenders and the public at large by encouraging people to do the assessments and some AODA and stuff before they even enter a plea. A lot of people, even though they get court ordered it, wind up not doing it. So it's better to protect the public, and that's why we have those guidelines. Have those guidelines to incentivize that. And the defendant's done that here. I think it's appropriate to follow them here.
Stop the tape. Did you catch that number? A 0.314 BAC. That isn't just drunk. That is dangerously close to the 0.40 fatal limit. To put that in perspective, that's nearly 4 times the legal limit. The prosecutor isn't exaggerating when he calls this borderline alcohol poisoning. Getting behind the wheel at this level is essentially weaponizing a vehicle.
Hold up, did you catch that number? A 0.314 BAC. That's 4 times the legal limit and dangerously close to alcohol poisoning. The prosecutor even points out that 0.40 can be fatal. Imagine getting behind the wheel at that level. It's a miracle no one was killed.
I think the 0.314 BAC is really scary. That's a borderline alcohol poisoning level. 0.4 is when it starts to get fatal. So I hope that she's benefited from the treatment. Thank you.
Thank you. Mr. Schlitz.
Thank you, Your Honor. There's nothing glamorous about what happened that day, Judge. She was out drinking and unexpectedly decided to leave and drive. She hit a curb on a roundabout and got a flat tire. She was cooperative with law enforcement, but pretty upset with herself for having made that decision. Following that day, Judge, she did her Rule 25 evaluation in the state of Minnesota as soon as she could. She enrolled in treatment when it became available. She's treating through intensive outpatient treatment 3 times a week. She enrolled in the IDIP program, or a similarly situated program with Ms. Anderson. Months ago, she's already completed 105 hours of community service. She's got 12 more shifts reserved. I've got an email from the Catholic Charities that she's been doing some service with. The court may or may not be aware that she's got a Minnesota driver's license, and the state of Minnesota effectively bars anyone from driving for the entire period of an out-of-state revocation. So this is going to have some pretty serious consequences for her. She lives in St. Paul. She's going to have to find a job that is along the light rail, because that's the only way she's going to be able to have transportation. I think she's owned up to her poor choice that day, Judge. And she's ready to put this behind her and just kind of focus on trying to, maintain her sobriety one day at a time, Judge. As the court knows, nobody's perfect in that regard. But I think that she's trying, and she's done just about everything that we could ask someone in her shoes to do. And I think that the IDIP program is, successful in that regard. And I think that, it's certainly something that she's taken advantage of here, Judge.
All right, thank you, Mr. Schlitz. Ms. Fabian, anything you want to add or state for the court?
No, I'm good.
All right, thank you. Well, Ms. Fabian, this is that's a high BAC, 0.314. It's not the highest that I've seen in court here today, though, or not today, but in court at all. I think one of our highest was actually a 0.5 something. That's scary, and that somebody can actually live and walk around and have such a high blood alcohol content. A 0.314.
This is a rare moment. The judge is looking past the rap sheet and psychoanalyzing the defendant. By suggesting there's underlying trauma or issues, the judge is signaling that while the law demands punishment, the person needs a therapist, not just a jail cell. Question for you. Do you think a judge should consider a defendant's mental health when sentencing for a dangerous crime like a DUI?
Is very telling about a few things, that probably something's been going on with you for a while, and that perhaps you do have substance abuse issues with alcohol. And I'm hoping that that's something that you're going to be able to address, and that you're working with a therapist, not just an AODA counselor, but an actual therapist, because it's telling me that you have some underlying trauma or issues that are having a significant impact on your ability to find peace and harmony in life. And I'm not asking for you to tell me what those are. I can just feel that that is what's going on. And so hopefully through this conviction, you'll be able to realize and have some self-reflection and be able to face that head on and to empower yourself in your life. And OWI is very serious. It's serious because, especially with the BAC at this high of a level, you could have been injured, you could have been killed, someone else could have been injured, someone else could have been killed. The fact that the community is at risk with all OWIs, for the most part, most OWIs. So they are serious. You did take steps right away to get your assessment, to try and do the programming that you need, and you're working very hard at doing all of that community service, which that is showing positive for you. And you're accepting the responsibility, and you are saying you're going to be accountable. And this is going to hurt you in terms of more than just another conviction or an OWI conviction. As your attorney stated, it's going to significantly impact your life in many different daily ways. But hopefully you'll be able to work through all of that, and hopefully you'll be on that path to recovery. Body, mind, soul. I don't think that this is something where I need to go above and beyond the IDIP guidelines, because you did what you need to do and you're learning the things and you're trying to take control of your life and your drinking. Okay. So I think that because you went through the program, I think you should get the benefits of the IDIP guidelines.
Pay attention to the balance, jail time, fines, license revocation, interlock device, and community service. It's strict, but the judge actually goes lighter than she could have because Fabian started treatment early. This shows how courts reward proactive rehabilitation.
So what the court is going to do is I will assess $3,175 in fines and fees, 55 days of jail with 1 day of jail credit, 24 months of ignition interlock device, and 24 months of revocation of driver's license, 125 hours of community service. I will also note on the record you have 105 hours already completed, and so you just need to provide proof of that additional 20 hours to Ms. Anderson. And that needs to be done by the end of your sentence. I will grant you the ability to serve it on electronic monitor after the first 48 consecutive hours are sat. But while on monitor, I'm going to tell you the monitor is very sensitive, and it takes a photo of you when you do your blows, so we know that it is in fact you. I'm going to tell you that if it blows positive, it blows hot, that there is any amount of alcohol from any source, even if it's a 0.0001, this court finds that as a violation. And so you will be told by Ms. Anderson that you are immediately revoked and you must immediately report to jail to serve the rest of your time in jail. No good time, no Hubert. So I will give you the cautions of do not have any rubbing alcohol on or around your face when you're going to blow or near your machine when you're going to blow. Do not have any food that's made with any real alcohol, no tiramisu, no bang bang shrimp, no bourbon shrimp, nothing of that nature, because it will set the machine off. No aerosols around the machine, it will set the machine off.
Talk about zero tolerance. The judge just warned her that eating bourbon shrimp or using mouthwash could trigger a violation on her electronic monitor and send her straight to jail. No hearing, no excuses. It's called strict compliance. Could you survive an in-home jail sentence where even a piece of cake could cost you your freedom? Let us know in the comments.
This is strict compliance. You do not get a hearing to tell me, hey, judge, it was really mouthwash. I do not allow that type of hearing, okay? So be very cautious, be very careful. And you must prepay at least 30 days at a time for your monitor at $18 a day. You will be permitted to go to the grocery store 1 time a week. You can go to AA. You can go to doctor's appointments. You can go to your community service. You can go to work. You cannot go to a birthday party. You cannot go to your niece's graduation. You cannot go to anything other than what is specifically laid out and told to you by Ms. Anderson. If something comes up and you have a death in the family and would like to go to the funeral, you need to, in writing, request that, and I will let you know if you are approved or denied. This is an in-home jail sentence, and so it is a punishment, and as such, it should be somewhat of a punishment. When do you believe that you would be able to pay off the fines and fees?
She probably will need a payment plan, Your Honor.
All right, $500 a month to begin in October, and then $500 a month thereafter until paid off in full. If you experience a significant financial hardship and you do not believe that you would be able to cover that much every month, you need to fill out the financial form, file it with the court, and request a financial review hearing. I will go over all of your finances, all of your income, all of your expenses, and I'm going to tell you sometimes it actually goes in disfavor of the person requesting a a reduction in the amount. The court has actually sometimes raised that amount based upon the information that I have been provided.
Your Honor, I didn't mean to interrupt you. I'm sorry. I can provide some information to the court that she is not currently employed.
And that's not my problem. She
Okay.
has to figure that out. This is a penalty, and it should be a penalty. It is a consequence of her actions. But again, if she's unable to figure that out, that's where she would need to have a hearing in front of the court. I need your DNA. You're going to provide that in the jail. It's immediate report. So once you're done here, you're going to leave this building, go all the way around and report to the jail for your sentence. Ms. Anderson will be there to hook you on the monitor at her earliest convenience. You have 20 days to appeal. Should you fail to appeal within 20 days, you do lose that right. You can request to have your DNA expunged from the system through a written letter to the Department of Justice. It's easy, Google it, or your attorney can tell you how to do it. If you don't pay your fines and fees, not only will a civil judgment be entered against you because you're always going to owe it, but the court will issue a warrant. You could sit up to 6 months in jail. It's very important you figure out how to pay that off. Mr. Schmidt, what am I missing?
Nothing from me.
Mr. Schlitz.
Credit for any administrative suspension, Your Honor.
She can have credit for any administrative suspension she has received.
Thank
All
you.
right, thank you. Then we are adjourned. Immediately report, and they will take your DNA, and you will be good to go.
Thank you, Judge.
Connie and Mr. Schlitz, I'm going to take a 5-minute break. We'll be right back to hear the other case. All right, thank you.